So hi everybody, welcome back to our CMA classes. So let's continue the remaining section of Banking Regulation Act 1949 in this lecture, and hopefully we are going to complete this chapter in this lecture. ठीक है ना? So yes, we are going to start from section 22, licensing of banking company. As we know that no banking company can commence or carry on the banking business unless it hold the license. And who is going to give the license, who is going to grant the license to the banking company? Definitely it's going to be RBI. Okay, so we know that RBI is going to grant the license, okay, and even RBI can cancel the license. So do you think, is there any other organization or any other body, if the banking company wants to appeal, ठीक है, which is related to the cancellation of their license, so can they go for appeal? Yes, they can go to the central government within 30 days. Okay, so we are going to read in this section what is written about the licensing of banking company. So let's go and start it. ठीक है, no banking company can commence or carry on banking company in India unless it hold a license granted to it by whom? The RBI for the purpose. ठीक है, and the RBI may cancel a license granted to a banking company under this section if the company ceases to carry on its banking business in India. In these cases, the RBI is going to cancel the license. Okay, yes, first, if the banking company is ceased to carry on the banking business in India, if the banking at any time fails to comply with any of the condition imposed upon it. ठीक है, third, any banking company agree by the decision by RBI within 30 days MCQ. Appeal to whom? To central government. Okay, and with the decision of central government is going to be final. ठीक है, so no further appeal can be possible. Okay, so what is written in the section? No company shall carry on business in India unless it hold license. We know this, and which is to be issued by whom? RBI, and such license may be issued subject to such condition as the Reserve Bank may think to be imposed. Every banking company in existence of commencement of this act before expiry of 6 months from such commencement, and every other company before commencing banking company in India shall apply in writing to whom? To RBI, definitely, because RBI is going to grant the license. Okay, so they are saying every banking company before existence of this act, ठीक है, before existence on the commencement of this act, ठीक है, so they have a time limit. Okay, within that 6 further month they have to apply in writing to whom? To the RBI. Okay, for a license under this section, provided that in case of banking company in existence of the commencement of this act, nothing in subsection 1 shall deem to be prohibit the company from carrying on a banking business until it granted a license in pursuance of this section, or notice in writing informed by Reserve that the license cannot be granted to it. Okay, so यहाँ से पढ़ते हैं, provided further that the Reserve Bank shall not give a notice as aforesaid to the banking company in existence on the commencement of act before expiry of 3 years. Okay, so before expiry of 3 years, refer to subsection 1 of section 11 or such further period as Reserve Bank may under subsection think fit to allow. Third, before granting any license under this section, Reserve Bank may require to satisfy of inspection of books of the company or otherwise that the following conditions are fulfilled. That first, the company is in the position to pay its present or future depositor, okay, as their claims accrue. ठीक है, second, what that the affair of the company are not being or are not likely to conduct in manner detrimental to interest of the present or future depositor. First of all, again they are talking about the depositor. ठीक है, so they are saying the company, whether the company is willing to pay, okay, willing to pay, ठीक है, its present or future depositor, okay, in full claim. Second, they are saying that the discriminant the interest of present or future depositor. Okay, they are simply saying about the depositors. ठीक है. Third, that the general character of the proposed management of the company will not be prejudicial to the public interest or the interest of the depositors. ठीक है. So the RBI is going to keep these points in mind before granting the license, they're going to inspect of book of accounts which is related to 3 point, ठीक है, whether the company is able to pay in full, ठीक है, debt in full claim of the depositor present and future, ठीक है, and which is related to if that is going against the prejudicial to public interest or depositors, ठीक है, and second the same, and that the company has adequate capital structure, ठीक है, this is another. If the company is not having that capital structure, license नहीं मिलेगा. And earning prospect, that the public interest will serve by the grant of license to comply to carry on that having regarding to banking facilities available in the proposed principal area of the operation of the company. The potential scope for expansion of bank already in existence in the area and other relevant factor that the grant of license should not be prejudicial to the operation and consolidation of the banking system, consolidated with the monetary stability and the economic growth. And this one is the last. Any other condition, the fulfillment of which would, is an opinion of the Reserve Bank, be necessary to ensure that the carry on of banking business in India by the company will not be prejudicial to the public interest or the interest of the company. So, in short, they have said some of the condition which is to be fulfilled for granting the license by RBI. ठीक है, so these, first of all we have to keep something कि depositor is in the list, ठीक है, and public interest, ठीक है, if any of the act is done against the prejudicial interest of public, in that case, ठीक है, license नहीं मिलेगा. And the Reserve Bank may cancel a license granted to banking company under this section, ठीक है, if what I said earlier, if the company ceases to carry on the banking business, license cancel हो जाएगा. If the company at any time fails to comply with any of the condition which is imposed by the subsection, which the condition which is mentioned by RBI, if the company is have been failed to comply the conditions mentioned by RBI, in that case also, ठीक है, if at any time of the condition referred to subsection 3 or 3A which is not fulfilled, again they are saying provided that before cancelling a license of this ground that the banking company has failed to comply with or failed to fulfill of the condition referred, there is a bank, unless it is of opinion that the delay will be prejudicial to the interest of the company's depositor or public, and shall grant to the company of such term as specified an opportunity of taking the necessary step for the complying with the fulfilling of the such condition, which simply says कि opportunity of being heard is going to given, ठीक है, to the banking company. Okay, so yes, this was all about the section 22. You have to keep this mind that who is going to grant the license, and RBI definitely, and RBI can also cancel the license in following cases: if the companies ceases to carry on the banking business, ठीक है, and what if the conditions given by the RBI is not properly, or the banking companies fail to comply with the conditions, ठीक है, in that case also, ठीक है. So these are the things which we have to keep in mind in this section, ठीक है. What about this section 20, the restrictions on opening of new and transfer on existing banking of business? So what happens, no banking company can open a new place, ठीक है, of business whether in India or outside India. For that they have to take the permission from RBI or कौन, ठीक है. But in there is one exception, ठीक है, which is saying no permission is required for opening a temporary place for the business for period of 1 month, ठीक है. If the business is only done for 1 month, in that case no permission is required by RBI, ठीक है, the banking company can do it, ठीक है. So section 23, restriction on the opening of new and transfer existing places of business. Without obtaining the prior permission of RBI, no banking company shall open up new place of business in India or change otherwise then within the same city, town, village, location of the existing place business situated in India. No banking company incorporated in India shall operate a new place of business outside India or change otherwise within the same city, town, village in any country or area outside India, the location of existing place of business situated in that country or area, provided that nothing in this section shall apply to the opening of period not exceeding 1 month of temporary place of business within a city, town, village or environs thereof, within which the banking company already has a place of business for the purpose of affording banking facility to public on occasion or a exhibition, falana falana. ठीक है, तो सिंपल कहना है इससे, नो बैंकिंग कंपनी शैल ओपन अ न्यू प्लेसेस वेदर इन इंडिया और आउटसाइड इंडिया, सो विदाउट टेकिंग अ प्रायर अप्रूवल फ्रॉम RBI. ठीक है, सिंपल है, things are very simple. So yes, there is something that the banking company have to maintain. ठीक है, section 24 says the maintenance of percentage of liquid asset. Now we know what is liquid asset. ठीक है, नहीं बताऊंगी मैं यहाँ पे liquid asset क्या होता है. ठीक है, अपने को पता है, प्रोफेशनल है हम सब. ओके, सो आफ्टर द एक्सपायरी ऑफ 2 years फ्रॉम द कमेंसमेंट ऑफ एक्ट, एवरी बैंकिंग कंपनी शैल मेंटेन इन कैश, गोल्ड एंड अक्यूम्बर्ड approved securities valued at price not exceeding the current market price, the amount which shall not at the close of business on any day which should not be less than 25% of total of demand and liabilities. So we have to keep this in mind, क्या 25% of what? Total demand and time liabilities. ठीक है, total demand and time liabilities. And what about section 25? First they were saying about the liquid asset. Every banking company have to maintain this. ठीक है, 25%. ठीक है ना. And second, maintenance of asset in India. Section 25 says requires for the maintenance of asset equivalent at 75%. 75%. ठीक है, remaining 25% ऊपर, 75% section 25 में. ठीक है, and demand, which is demand and time liability, same thing. ठीक है ना, at the close of business of the last Friday of every quarter. ठीक है, now this thing, section 26, submission of return of unclaimed deposit. ठीक है, according to section, every banking company shall submit a return in prescribed form and manner which is given by RBI. ठीक है, to RBI definitely, giving particular regarding unoperated accounts in India for 10 years. ठीक है, if any of the which is related to unoperated accounts, ठीक है, related to banking area, banking business in last 10 years. ठीक है, so every banking company have to give this, have to submit a return. ठीक है, in a prescribed form. ठीक है, to whom? To RBI definitely. Okay, and this return is to be submitted within 30 days after the closure of each calendar year. In case of fixed deposit of 10-year period is counted from the date of expiry of such fixed period. ठीक है, so yes, this is to be maintained by every okay. Next, section 27, submission of return form etc. to RBI. Under this section, every banking company shall submit to RBI return in prescribed form and manner showing its asset, let me write here, showing it asset and liability. ठीक है, in India on the last Friday of every month. Beside, the RBI may at any time direct a banking company to furnish the statement and information related to business or affair of the banking company with the prescribed period mentioned therein. Such direction may be issued by RBI consider it is necessary or expedient to be obtained for the purpose of this act, and the RBI may call for information every half and regarding the investment of banking company and classification of advance given in respect of industry, commerce and agriculture. So this thing which I have already highlighted, we have to keep this in mind. ठीक है, next, accounts and banking and balance sheet of banking company, section 29. Banking company have to prepare the accounts and balance sheet as per क्या, as per 3rd schedule. ठीक है, and it should be signed by at least 3 directors. ठीक है, where no director exceed 3. If no of the director falls short of 3, then all director must sign the accounts. Okay, in case of banking company incorporated outside India, account must be it should be signed by whom? The manager, principal officer or of the company in India. ठीक है, section 30 says about the auditing of banking company. Okay, as we know, section 29 was of accounts and balance sheet. ठीक है, so yes, in section 30 we are going to continue this. ठीक है, balance sheet and P&L made in accordance with whom? Section 29. ठीक है, must be audited by a person qualified under law to work as auditor. है ना, 3 directors have to sign this, है ना, हाँ, we have to keep this in mind. Next, the banking company must obtain the RBI approval before appointing, before removing, or before or reappointing any of the auditors. ठीक है, we are talking about auditors here. Okay, so the banking company have to take the RBI's permission, ठीक है, approval before appointing, before removing or reappointing any of the auditors. ठीक है, when RBI is not satisfied with the financial statement of bank, it can give order for conducting a special audit. ठीक है, when if the RBI is not satisfied with the financial statements of the banking company, in that case the RBI can simply give an order to conduct special audit. जनाब, ठीक है, we know टैक्स में हमने पढ़ा है, ठीक है, कहीं ना कहीं ये चीज़, ठीक है, and cost of such special audit must be borne by the banking company itself. Okay. Auditors liability scope power are as same as given in section 222 of Companies Act 1956. Additional disclosure is to be maintained whether information given is correct and present, true and fair, whether the transaction done by company comes under the purview of power of company, safety of asset, any other matter which is to be disclosed, and such auditor report must be submitted to RBI in 3 copies in such a prescribed manner. RBI may extend the further this period to further next 3 period. ठीक है, so yes, RBI may extend the period of 3 months for furnishing of such return if RBI find it justified to do so, in that case only. ठीक है, so yes, this section 35A, power of RBI to give directions. Okay, so power of, as we know this part कि हमने already इसमें से 2 पार्ट कवर कर चुके हैं, which is related to public interest. Okay, and ये prevent the affair of any business, any banking company which is related to depositor वाला top point. ठीक है, let me write here. Okay, so first of all, when is the RBI going to give the directions, ठीक है, which if any of the banking company is doing the things which is against public interest or interest of banking policy, or to prevent the affair of any banking company depositors, or to secure proper management of banking company. ठीक है, when any of the thing is done in this favor or in this part, ठीक है, in that case only the RBI is going to give the direction which is related to public interest. ठीक है, yes, interest of banking company, secure proper management, and ये prevent the affair of the banking company depositors वाला point. ठीक है, so yes, where the banking company satisfy that in public interest or in interest of banking company, or to prevent the affair of any banking company being conducted in a manner detrimental of the interest of the depositors, or in manner prejudicial to the interest of the banking company, or to secure proper management of the banking company generally, it is necessary to issue guidelines to banking company generally or to any banking company in particular. It may from time to time issue such direction as it deem fit, and the banking company or banking company, as the case may be, shall be bound to comply with such direction which is issued by whom? The RBI. ठीक है, the banking company have to follow that guidelines which is given by the RBI, the direction which is given by the RBI. ठीक है, okay. The Reserve Bank may, on representation made to it or on its own motion, modify or cancel any direction issued, and in so modify or cancelling any direction may impose such condition as it think fit, subject to which modification and cancellation shall have effect. So in simple, can I say RBI is going to give directions related to 4 parts. ठीक है, related to public interest, related to the interest of banking company, ठीक है, proper management and prevent the affair of the banking company of depositor वाला part. ठीक है, so yes, they can modify or alter, ठीक है, any of the directions. Further, they can also modify, they are saying, and this direction is to be done by followed by the banking company. They cannot go against these directions. ठीक है, they have to comply with this direction which is given by the RBI. ठीक है, simple बात लिखी हुई है. Then comes power of central government, section 35AA. Section 35A was Reserve Bank वाला ना, ये याद रखो. ठीक है, power of Reserve Bank to give the directions. Now it's saying the power of central government. ठीक है, now the central government can also, ठीक है, initiate IRP, insolvency resolution process. We know what is this now. ठीक है, so yes, the central government can initiate IRP. ठीक है, to whom? the Reserve Bank, to RBI, ठीक है, to conduct the RBI, the central government can initiate this to initiate this IRP, which is to be done by the Reserve Bank, ठीक है, but on what basis? If the default under the provision of Insolvency Bankruptcy Code 2016 is done, in that case only the central government can initiate this IRP. Okay, so yes, section 35AA says about the power of central government. 35A was of RBI, we know this, ठीक है, to authorize Reserve Bank for issuing direction to banking company to initiate the banking resolution process. The central government may by order authorize the Reserve Bank to issue direction to any banking company or banking companies to initiate banking resolution process in respect of default under the provision of Insolvency and Bankruptcy Code 2016. That's it. There was nothing more in this section. Let's go for the next section. Section 35AB says the power of Reserve Bank to issue direction in respect of stressed asset. ठीक है, पहले वाला कौन सा था? They were also giving the direction, ठीक है, which was related to 4 part, ठीक है, section 35A, ठीक है, then 35AA was of central government, ठीक है जी, हाँ जी, initiate IPR, है ना, इंसॉल्वेंसी रेजोल्यूशन प्रोसेस, IRP, गलत बोल दिया मैंने, ठीक है, कोई बात नहीं. देन 35AB says about the power of RBI, say again, but which is related to stressed asset. Now what is this stressed asset? We have to find out now. Stressed asset is equal to non-performing asset plus return of asset plus restructured loan. So 3 things are there: non-performing asset, let me write here, non-performing asset, ठीक है, and return, if there is any return of asset, okay, return of asset and restructured loan, ठीक है, this is what the stressed asset is, ठीक है. Then when these assets are non-performing, we know what is that, NPA ना, हाँ, they became doubtful and NPA, stressed NPA asset, हाँ, those, हाँ, एक second, if those assets don't recover then became a bad loan before the period of 90 days, they are called the stressed asset. Now I know what is the meaning of stressed asset, ठीक है. So the RBI is going to give the directions which is related to stressed asset, ठीक है. So without prejudicial to provision of section 35A, ठीक है, RBI may from time to time issue direction to any banking company or banking company for resolution of stressed asset, ठीक है. The Reserve Bank may specify one or more authorities or committees with such member as RBI may appoint or approve the appointment to advise any of the banking company or banking companies on the resolution of stress asset. Nothing much there was, ठीक है. So yes, they can issue directions which is related to resolution of stress asset, and apart from that they can also appoint in some of the authorities or communities, ठीक है, for the stress asset. Let's go for section 35, which is amendment of provision related to the appointment of managing directors in the case of banking company. Okay, no amendment of any provision related to maximum permission number of director or appointment or reappointment or termination of appointment or remuneration of chairman, managing director, any other director, full-time director or the manager, chief executive officer or by whatever name called, ठीक है. यहाँ तक इतना ध्यान नहीं रखना, we know which people we are talking about, ठीक है. Yes, we know this, ठीक है. Whether the provision be contained in the company's memorandum or article, यहाँ से main है, whether that the provision contained in the company's memorandum or article of association or in agreement entered by it any resolution passed by the company in general meeting or by its board of director shall have effect unless it is approved by RBI. So what they are saying, the RBI, whatever it is written in somewhere or not, whether it's passed by the company in general meeting, whether by the board of directors or if it is written in somewhere, ठीक है, they are talking it cannot give effect unless it is approved by Reserve Bank, ठीक है. तो ये अपन को याद करना है, it is to be approved by whom? By the Reserve Bank. Second, no appointment of reappointment or termination or appointment of a chairperson or managing or whole-time director, manager or chief executive officer by whatever name called shall have effect unless such appointment, reappointment or termination of appointment made with the previous approval of RBI. Simple same चीज़ बोली गई है, ठीक है. Now this removal of managing director or any other person 35AA 36AB. 36AA, 36AB. Under this section, the RBI has power to remove the manager and other person from office and appoint the additional director. ठीक है, बस इतना additional person. ठीक है. So yes, hope so. This was also cleared. Let's go for the suspension of business. Section 37. The High Court may on application of the banking company which is temporarily unavailable meet its obligation make an order. ठीक है. So here comes some other point which is related to High Court. ठीक है. A copy of which is to be shall cause to forward it to the RBI stating staying the commencement or continuation of all actions and proceeding against the company for fixed period of a time on such terms and condition as it shall think fit and proper as may from time to time extend the period, so however that the total period of moratorium shall not exceed 6 months. ठीक है. Hope so this was also clear, which was related to suspension of the business or banking company. ठीक है. Now comes section 38 to 44 which says winding up by whom, by the High Court. ठीक है. यहाँ पे RBI नहीं, यहाँ पे High Court is meant. ठीक है. If the banking company is unable to pay its debt, okay, if the application of its winding up has been made by Reserve Bank under section 37 they are saying, ठीक है, and the Reserve Bank shall make application under this section for winding up banking company if directed so to do by the order under clause B subsection 4 of 35. they are talking about the 35 section. ठीक है. Reserve Bank may make application. तो पहले इन्होंने बोला if the banking company is unable to pay its debt, okay, if it is the order is made by the Reserve Bank, ठीक है, under section 35 also, okay, and Reserve Bank definitely they have same the application for winding up has been made by RBI, ठीक है, under section 37. This point is different, ठीक है, and this point is different, okay, so don't mix up, okay. Or if the banking companies fail to require the condition which is specified under section 11, minimum paid up capital plus reserve, याद है ना, हाँ. Or they are saying about section if they are unable to maintain, if there was any reason for provision of section 22 became disentitled to carry on the business under of banking in India which is license of banking company 22, ठीक है. Or it has been prohibited by receiving the fresh deposit by the order under clause A of subsection 4, section 35 or clause B of subsection 3A of 42 of the Reserve Bank of India, okay. Or fourth, they are saying having failed to comply with the requirement of the act or other than the requirement laid down in section 11, okay, has continued such failure or having contravened any provision of this act, has continued such contravention beyond such period or period as may be specified in that behalf by the RBI from time to time after giving a notice. So these are the things which we have to keep in mind, which is related to winding up of banking company by whom, by the High Court under section 38 to 44, ठीक है. If they are unable to pay debt, ठीक है, winding up application is done given by whom, the RBI under section 37 also and 35 वाला section also, ठीक है. Yes, they have to keep this thing in mind, ठीक है. If they are unable to pay its debt के साथ साथ and they have to comply all the section 11, 22 and some of the section 35 clause 4 वाला, subsection 4 वाला, ठीक है, and if any of the contravention is done by them, ठीक है, in that case definitely winding up of banking company is done by whom, High Court, ठीक है. So let's go for the next part, power of central government to acquire a banking business. Yes, there is a power. CG may acquire banking company by compulsorily transferring shares or otherwise, ठीक है. That's it. There is nothing much more in this section. This is going to the last section, section 44A. Amalgamation of banking company, okay. So do you think this is going to happen? Amalgamation of banking company is going to happen? Yes, but when it's approved by 2/3 of the majority of total voting ratio of the shareholder in general meeting, then only it's going to happen, ठीक है. So yes, let's go for this section, the last section of this lecture. Section 44A, which is of amalgamation of banking company. The procedure for amalgamation of banking company are given under this section. As per this section, the scheme of amalgamation, the term and condition of amalgamation is to be approved by 2/3 majority of total voting ratio of the shareholder in the general meeting. The unwilling shareholders, yes. So what do you think? Those who are unwilling to amalgamate, those who are not agreeing, okay, to give their shares and all. So what happens to them? Are they going to get any compensation? Yes, let's read this. Okay? The unwilling shareholder are entitled to receive the value of their shares as may be determined by RBI. So definitely they are going to receive some compensation, okay? Which is going to be determined by whom? RBI. The RBI has to sanction the scheme of amalgamation after shareholders' approval. First of all, we have to give the conditions. What is the condition for approval? 2/3 of majority. 2/3 of majority. Okay? Of majority. Okay? Of voting ratio of the shareholders in the general meeting. Okay? So keep these things in mind. Okay? So RBI has to sanction the scheme of amalgamation after shareholders' approval. The asset and liability are transferred to acquiring bank according to the direction of RBI mentioned in sanction order. The RBI issue order for dissolution of first bank on the specified date. During the preparation of scheme of organization, RBI may suspend the business with approval with the central government. As per the amendment in October 2020, RBI may initiate a scheme for reconstruction amalgamation without imposing moratorium. Okay? So those who don't know what is the meaning of moratorium, we already discussed. Okay? And here I have also written. So that's it guys. This is the completion of Banking Regulation Act 1949. Hope so you get something here. Okay? Hope so this video was benefited to you. If it was, what you have to do? Hit a like button, subscribe my channel and share this video to those who are doing CA, CMA. Okay? Till then we'll meet in the next video. This is Soumya Santosh. Toodles guys.